Are you a Canadian employee who's about to quit their job and you're wondering what rights and obligations you have? That's what today's video is all about. I'm Anthony Moffat, a lawyer at Labor Rights Law Office, your go-to virtual law firm. After the video, if you have any questions about your resignation, give us a call for a free 30-minute consultation over Zoom. Our contact information is below. Let's get to the questions. In British Columbia, there's nothing in your Employment Standards Act that says you have to give your employer notice before you quit. But that's not the end of the story. You may have something in your employment contract that says you've got to provide notice. Or depending on the length of service, salary, and the time it would take for your employer to replace you, you may also owe your employer more than the 2 weeks notice many employees give their employers before leaving. Even if you're a rank and file employee and you think your employer won't miss you, giving notice is still a good idea. Giving your boss plenty of notice will help you protect your professional reputation and make it more likely that your employer will give you a good reference down the road. You never know how the new job will work out, and you can never have too many good references. The short answer is it depends. Sometimes it's spelled out in your employment contract. Otherwise, the notice you should provide your employer depends on your role and responsibilities, how long you've been there, and how hard it will be for your employer to find a suitable replacement. An executive or employee in a key position will be expected to provide far more notice than a rank and file employee. Here's the bottom line. If you're a key employee or you think your employer might lose a lot of money if you left suddenly, you should talk to an employment lawyer before you provide your resignation. If you're careful to say that you're resigning on a certain date, your employer is not entitled to fire you earlier than that. If your employer does fire you earlier than that, you can argue that you were terminated without cause and are owed severance. Depending on your employment contract, you may be entitled to all the notice you would have otherwise received, just as though your employer had fired you out of the blue for no reason. Here's how that works. Basically, the courts see resignation with terms as an offer to resign, and the employer must accept the offer as stated. If the employer doesn't, it's just like they're firing you for no reason. Normally, the answer here is no. Employees who quit their jobs voluntarily aren't entitled to termination pay under employment standards legislation, pay in lieu of notice at common law, or even employment insurance. That said, there are exceptions to this rule. For instance, if the employee can demonstrate that they had no choice but to leave because of something like harassment, a demotion, or unsafe work, they might be able to argue that they were constructively dismissed. If this is the case, such an employee may be owed compensation as though the employer had terminated their employment. Check out our blogs for more information about constructive dismissal, or give us a call for a free 30-minute consultation. Heated resignations are pretty common in the workplace. You can think of the big cliche scene here. An employee gets frustrated at something their boss says one afternoon, yells, "I quit," and then storms out of the office. The law recognizes that decisions that are made when the employee is overly emotional often shouldn't be enforced. Courts have recognized that employers can't always accept a resignation right away when it's given in anger or frustration. Whether a court sees an employee's resignation as something that should stick in situations like this depends on a number of things, including how long the employee's been with the company and whether the outburst was out of character. After you quit, you can still have obligations to your former employer. One important source of these obligations is often the employment contract. For example, there might be something in your contract that says you can't talk to the employer's customers for a period of time, or something in there that says that you're not even allowed to compete in the same business. But your obligations aren't always spelled out in an employment contract. Even without an employment contract, you might have significant obligations after you leave. It really depends on your role in the company. If you're a key employee, or you have an employment contract with language restricting what you do after you leave, it's a good idea to see an employment lawyer before you resign. That way, you can understand what legal risks might be involved with your new job. Employees are sued by their former employers more often than you'd think, especially if the former employer suspects the employee's new job is helping the competition and costing them money. We hope you enjoyed today's video on the law of resignation. If you're an employee that's quit or you're thinking of quitting, why not reach out and give us a call? We offer free half-hour consultations and would be honored to help you.